Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an important update in the Kashi Vishwanath Gyanvapi land title dispute cases. The Allahabad High Court has today held that the batch of civil suits filed by Hindu worshippers seeking right to worship in the Gyanvapi mosque and restoration of a temple at the disputed place pending before the Varanasi court are not barred by Places of Worship Act of 1991. The suit pending before a Varanasi court seeks to restore an ancient temple at the disputed site currently occupied by the Gyanvapi mosque. The petitioners have contended that the mosque is a part of the temple. The Anjuman Intizamiya Masjid Committee, which manages the Gyanvapi Mosque in Varanasi, and UP Sunni Central Waqf Board have contested against this. According to them, the suit was prohibited by Places of Worship Act. For context, let me tell you, the Places of Worship Act prohibits conversion of a religious structure from its nature as it stood on the date of independence. The bench of Justice Rohit Ranjan Agarwal has rejected the pleas filed by the Masjid Committee. The court added that Masjid compound can have either a Muslim character or a Hindu character, and the same cannot be decided at the stage of framing of issues. The court also said that the Archaeological Survey of India survey conducted in one suit shall also be filed in the other suits, and if the lower court feels that a survey of any party is necessary, the court may direct the ASI to conduct the survey. The court has significantly observed that religious character of the Gyanvapi complex as it existed on 15th August 1947 is to be determined by the Varanasi Civil Court in light of documentary as well as oral evidence led by both parties, and so unless the court adjudicates upon this issue, the same cannot be called either as a temple or a mosque. The Supreme Court today granted interim protection from arrest to the Vice Chancellor and other officials of the Sam Higginbotham University of Agriculture, Technology and Science in a case pertaining to alleged forceful religious conversion of a woman to Christianity. Let me give you a brief context here. The victim is an alumnus of Allahabad University who completed her BA in 2005. During her student days, she met one of the accused, that is Rekha Patel, who used to allure her fellow girls by providing gifts and other articles of their choice to convert them to Christianity. The FIR, though lodged in November 2023, further stated that the victim belonged to the lower middle class and was trapped by Patel, who took her regularly to the church. That she was regularly subjected to sexual exploitation by the Vice Chancellor of the university and was pressurized to bring women for conversion and other illegal works. The FIR states that she was allegedly baptized and thereafter offered the job as a stenographer at the university. However, she was later sacked in the year 2022 after she was found guilty by the Internal Inquiry Committee for cheating a person of 5.5 lakhs. Last week, the Allahabad High Court refused to quash an FIR lodged against the VC Dr. Rajendra Bihari Lal and Director Vinod Bihari Lal and 5 other officials of the university. The court had observed that no true religion on the earth would approve of malpractices by the priest or the godman. Today, the Supreme Court vacation bench, comprising Justices Aniruddha Bose and K.V. Vishwanathan, was hearing an SLP against the High Court order. Senior advocate Dushyant Dave argued for the accused, and the bench stayed the High Court order till 5th January or until further orders were passed in the matter, whichever was earlier. Also, let me tell you, the university VC was also accused in a mass religious conversion case earlier. In that matter, the Supreme Court had stayed his arrest in March this year. The Madras High Court today set aside the order of a trial court acquitting Tamil Nadu Higher Education Minister K. Ponmudi and his wife in a disproportionate asset case filed by Directorate of Vigilance and Anti-Corruption, that is DVAC. The prosecution case was that Ponmudi had amassed wealth disproportionate to his sources of income during his tenure as the Minister for Mines and Minerals in the DMK government. It was alleged that being a public servant, he had committed an offence punishable under Prevention of Corruption Act. The agency also claimed that his wife had abetted by aiding Ponmudi in acquiring and possessing pecuniary resources and properties on his behalf disproportionate to the known sources of income. The trial court had acquitted the minister and his wife. But now, Justice G. Jayachandran of the Madras High Court has allowed the appeal preferred by the DVAC against this order, holding that the trial court had erred in acquitting the minister and finding the minister guilty of offences under Prevention of Corruption Act. The court has directed the minister and his wife to appear before the court on 21st December. The Bombay High Court has today granted bail to senior journalist and activist Gautam Navlakha, an accused in the Bhima Koregaon Elgar Parishad case over alleged Maoist links. After the NIA urged the court to stay the order for a period of 6 weeks, the court stayed the order for 3 weeks. The National Investigation Agency has accused him of furthering the banned CPI Maoist agenda and conspiring to overthrow the government. He has been accused of instigating the caste violence that erupted at Bhima Koregaon in 2018. In the charge sheet, NIA has also alleged that Navlakha supported the Kashmir separatist movement. The 73-year-old human rights activist has been in custody since 2018 and has been booked under various provisions of IPC and UAPA. The order granting bail was today passed by a division bench headed by Justice A.S. Gadkari. In another update, the Kerala High Court today reserved for orders the anticipatory bail plea moved by a former senior government pleader in the case pertaining to alleged sexual assault of a female client by him in the guise of providing legal assistance for her. As I have told you before, the victim in this case, who was also the victim in an identical case wherein she had been sexually exploited by another individual, had allegedly approached the petitioner for settling her case before the court. Following the allegations, he had resigned from the post of senior government pleader. The allegation against the lawyer is that he established an unholy relationship under the guise of taking instructions and raped the victim at her house and his office, and that he transmitted her nude photos to others. The lawyer moved the application for anticipatory bail and submitted that the allegations were false and that the registration of the case itself was a calculated attempt from the part of some professional rivalries. Justice Gopinath P. reserved the judgment today and is set to pronounce the verdict in the case on this Friday, that is 22nd December. Stay tuned with us. The District Consumer Disputes Redressal Commission North Chennai has held Deccan's Park Hotel liable for deficiency in service, for negligence and failure to exercise reasonable care in providing valet parking services, which subsequently led to stealing of vehicles from the hotel's parking. In this particular case, the complainant's vehicle went missing from the hotel. He had handed over the car key to the valet parking driver and received a valet parking tag. But later, upon handing the valet tag back to the hotel security personnel, he was informed that his car was missing from the hotel premises. Upon checking the in and out register, it was revealed that the car had left the hotel some time ago. Despite his efforts, none of the hotel's staff provided any assistance in recovering the vehicle. Eventually, he contacted the police and filed an FIR, and was informed by the police station that the vehicle had been in their possession due to an accident which caused significant damage to the car. He then filed a consumer complaint. In response to the complaint filed, the hotel argued that the vehicle was stolen by an individual who used a counterfeit tag. The hotel contended that there was no deficiency in their services, as the thief used a fake tag to deceive the staff into handing over the car. But the District Commission emphasized that the hotel's duty of care extends beyond the mere act of parking the car, and it is obligated to ensure the safety and secure return of the vehicle to the owner in its original condition. The hotel was thus directed to pay a compensation of 55,000 rupees to the complainant. Today was the 12th day of the winter session of the Lok Sabha. It today passed the National Capital Territory of Delhi Laws Special Provisions Second Amendment Bill of 2023. The legislation, introduced on 13th December by Urban Affairs Minister Hardeep Singh Puri, seeks to extend the validity of a central act addressing unauthorized colonies and slum relocation. The bill aims to provide continued protection from punitive action for various unauthorized developments in the National Capital Territory of Delhi. This includes slum dwellers, hawkers, unauthorized colonies, schools, religious and cultural institutions, and agricultural godowns. The National Capital Territory of Delhi Laws Special Provision Second Act of 2011, which was initially valid until 31st December 2014, has seen many extensions. The most recent amendment, passed in 2021, extended it until 31st December 2023. And now the Lok Sabha approval extends it further until 31st December 2026. This bill was passed by the Lok Sabha through a voice vote today afternoon. 49 opposition members were suspended from the Lok Sabha today, taking the tally of the opposition MPs suspended in the session from both the houses to 141. For more information on the bill, do visit livelaw.in. And lastly, the Delhi High Court today adjourned to 4th January the plea moved by Trinamool Congress leader Mahua Moitra, challenging cancellation of her government accommodation. As you know, Moitra was recently expelled from Lok Sabha in connection with the cash for query allegations. The Union Government's Directorate of Estates has asked her to vacate the government accommodation by 7th January 2024. Moitra has challenged the order and has sought a direction to allow her to retain the possession of her government accommodation till the results of 2024 general elections. The plea states that while Moitra's bona fide claims as to invalidity of her expulsion from the Lok Sabha remain pending before the Supreme Court, she cannot be evicted from her government residence. Also, she states instability in accommodation would pose a significant impediment to her ability to host and engage with party members, parliamentarians, fellow politicians, visiting constituents, etc., which is essential, especially in the lead-up to a general election. Justice Subramaniam Prasad deferred the hearing, noting that adjudication in the matter will be directly impinging on the proceedings in the plea against her expulsion before the Supreme Court. It accordingly adjourned the matter for hearing on 4th January in view of the fact that Moitra's petition challenging her expulsion is coming up before the Supreme Court on 3rd January. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.